Have you ever seen an order like this? It's an appointing order for a summary court-martial. And sooner or later, almost every officer is faced with the possibility of being named on such an order to conduct a summary court-martial. Sure, the way to do it is all there in the books, in the Manual for Courts-Martial, the Naval Supplement, and in other available sources. But still, it would help to see how it's done, wouldn't it? Well, that's easy enough. Let's go aboard ship and get the word from someone who has already served a summary court-martial. Can you give us a hand, Lieutenant Mason?
I'll do my best. Here's a case that was tried on this ship week before last. It was reviewed and has just received final approval. But let's begin at the beginning. Naturally, every case begins with an offense. In most cases, the offense is first noted on a report slip. Following this, in order to learn the facts, the commanding officer usually orders a preliminary inquiry. If it appears that trial by any type of court-martial may be required, a charge sheet is made out, signed and sworn to, and the case is returned to the commanding officer for disposition.
Well, what possible courses of action may he take?
If he sees fit, he may dismiss the charges. Or he may handle the case at mast, where he may again dismiss the case, or warn the accused, or impose suitable non-judicial punishment under Article 15 of the Code. If the offense is serious, the CO may refer the case to a summary court-martial or to a special court-martial.
How about a general court-martial?
If the facts developed at the preliminary inquiry establish that it's a very serious case, he may order a pretrial investigation, which could lead to a recommendation for a general court-martial. A pretrial investigation is required before a trial by a general court-martial.
Then these are all possible courses of action under the Uniform Code of Military Justice.
Yes, that's correct. However, here's what happened in this case when it came up at mast week before last.
This is a case that involves drunkenness on board ship, Captain. Here's the preliminary inquiry report and the man's service record.
Durand, you are charged by Bowman, boatswain's mate second, with being drunk in the 2nd Division compartment on Monday, 17 March at about 22:10. But before proceeding further, I want to remind you of your right to remain silent. You don't have to say anything which may tend to incriminate you. Is that clear?
Yes, sir.
Bowman, what do you know about this?
Well, Captain, on Monday night I was a petty officer of the watch. As I was making my lights-out inspection, about 22:10, I heard a loud commotion in the 2nd Division compartment. When I investigated, I found Durand here marching up and down the space, yelling at the top of his lungs.
What was he yelling?
Well, Captain, he was shouting, "Where's my sack? Who stole my sack?" And when they tried to shut him up, he said, "I don't care who hears me."
Was the senior petty officer in the compartment doing anything to maintain order?
Yes, sir, Captain. He and 3 or 4 men tried to control Durand, but he gave them all a bad time. We finally got Durand up to sick bay.
Was he drunk?
Yes, sir, I think he was.
Mr. Rogers,
Yes, sir.
you're Durand's division officer, aren't you?
Yes, sir.
What kind of a man is Durand?
Well, Captain, he's a good man. Never have any trouble with him as far as his work is concerned. He just gets fouled up when he goes on liberty.
Durand, I'd like to hear your side of the story, if you'd care to tell me.
Well, Captain, I know I had a few drinks on the beach. Don't remember anything after I returned to the ship. Must have been bad liquor.
Durand, weren't you up here just 3 weeks ago for being drunk?
Yes, sir.
I gave you a week's restriction for that. Is that correct?
Yes, sir.
I'm referring this new charge to a summary court-martial.
Once an offense has been referred to a summary court-martial for trial, the next step is to inform the accused, as soon as it is practicable, of the nature of the charges against him, to advise him of his rights and to determine whether he will consent to trial by summary court.
Mr. Mason,
Yes?
you wish to see me, sir?
Oh, Duran, come in. Sit down, Duran.
Thank you, sir.
Before discussing the case, the summary court considers the background and educational record of the accused and phrases his explanation accordingly.
Durand, an offense charged against you has been referred to me as summary court-martial. According to your record, you're a high school graduate, is that correct?
Yes, sir.
I'm about to explain certain matters to you. If anything I say isn't perfectly clear, say so and I'll go over it again.
Yes, sir, I will.
You are charged with being drunk in the 2nd Division compartment aboard this ship on 17 March 1952, about 22:10. This charge has been referred to me for trial by the commanding officer. Bauman, bosun's mate second, is the accuser. Here is your copy of the charge sheet containing both the charge and specification.
The accused must be furnished with a copy of the charge sheet prior to trial and be given a reasonable time to inspect it and prepare his defense.
You may plead either guilty or not guilty to the offense. Your guilt must be proved beyond a reasonable doubt in order for the court to find you guilty. The following persons may be called as witnesses against you: Walker, bosun's mate third; Bauman, bosun's mate second; Jordan, seaman; Smith, seaman; and Brown, seaman apprentice.
May I have permission to question the witnesses, sir?
Yes. You have the right to question these witnesses yourself, or I will ask them any proper questions for you if you tell me what you want me to ask them.
Well, can I bring in any witnesses I want, sir?
Oh, certainly you may do that. You may call witnesses to testify in your behalf or produce other proper evidence. And I will assist you in securing such witnesses or evidence if you tell me what you want. In other words, Durand, I will act for you as well as for the government. Do you understand?
Yes, sir.
At your own request, but not otherwise, you may be a witness in your own behalf.
If I don't talk, will it go harder on me, sir?
No. The fact that you wish to remain silent will not be held in any way against you. Of course, if you choose to testify, I can cross-examine you the same as any other witness. If you plead guilty or found guilty, you may, nevertheless, introduce witnesses or other evidence relating to your military record or to any circumstances surrounding the offense which would tend to show that it's less serious than it seems to be on the face of it. You may also make an unsworn statement as a plea for leniency.
Well, if I plead guilty, or if I'm found guilty, well, how much can I get?
The maximum sentence which may be adjudged for the offense charged is 1 month's confinement at hard labor and forfeiture of 2/3 of 1 month's pay. You may refuse trial by summary court if you desire. But if you object to such trial, I have to refer the case back to the captain, and he may award you a special court-martial. Do you understand all that I've said?
Yes, sir.
Will you read and sign this summary of the information I've just given you? Keep a copy of it for yourself.
This prepared summary not only informs the accused of his rights, but also indicates, when signed, that the summary court-martial has explained these rights to the accused.
Right there. It's your copy. Unless you have some proper objection, I'm going to try your case tomorrow at 1400 in the ward room. Do you have any objection?
No, sir.
Do you intend to consent to trial by summary court-martial?
Yes, sir.
If you've decided, will you tell me if it is your present intention to plead guilty or not guilty?
I want to plead guilty, sir.
You understand, you may change your mind on these matters any time prior to trial.
Yes, sir.
Do you have any further questions?
No, sir.
Very well, that'll be all, Durand.
Yes, sir.
It is important to note here that the questions asked and the answers given during this preliminary interview with the accused serve a dual purpose. First, they inform the accused of the elements of the case against him and of his rights and privileges. Second, while the answers given by the accused are not binding, they assist the summary court in his preparation of the case for trial.
Mr. Mason, I have Durand here, sir.
Very well, bring him in.
Aye, aye, sir.
Sit down, Durand. The court will come to order.
As soon as the court comes to order, the exact time is noted and the convening authority and the OOD are notified.
Orderly, take these to the captain and the OOD.
Aye, aye, sir.
I will now read the order appointing this court. Stand, Durand. USS Grady, DD 1101, care of Fleet Post Office, New York, New York. File DD 1101, slant A17-3, serial 744. Dated 4 February 1952. From Commanding Officer to Lieutenant John E. Mason, United States Navy. Subject, appointing order for a summary court-martial. 1. A summary court-martial is hereby ordered to convene on board the USS Grady, DD 1101, at 1000 hours on 5 February 1952, or as soon thereafter as practicable, for the trial of such persons as may properly be brought before it. 2. Effective this date, Lieutenant John E. Mason, United States Navy, is appointed summary court-martial. Signed, Edward R. Brumley, Commander, United States Navy, commanding. The court is ready to proceed with the trial in the case of the United States against Norman S. Durand, Seaman, United States Navy, who is present in this court. Seated. Durand, are you ready for trial?
Yes, sir.
The court wishes to advise you that it is your right to refuse trial by summary court. But if you do so, you may be tried by either a special or a general court-martial. Knowing this, do you consent to trial by summary court?
Yes, sir.
Indicate your consent by checking here and your signature in this space. The general nature of the charge in this case is drunk on board ship. The charge was preferred by Ballman, boatswain's mate second, who was the accuser, and was served on you by me, Thursday, 20 March, 1952, and properly referred to this court for trial. I will now read the charge and specifications. Stand. Charge. Violation of the Uniform Code of Military Justice, Article 134. Specification. In that Norman S. Durand, Seaman, United States Navy, USS Grady, was on board said ship on or about 17 March 1952, drunk. I am about to ask you how you plead. But before I do so, do you know of any reason why this case should not proceed to trial at this time?
No, sir.
How do you plead to the specification?
I want to plead guilty, sir.
How do you plead to the charge?
Guilty, sir.
Let me sit down. Durand, you have pleaded guilty to the specification and the charge. By so doing, you have admitted every act or omission charged and every element of the offense. In other words, you admit that you were drunk while on board this ship. Your plea subjects you to a finding of guilty without further proof, and you may be sentenced by the court to the maximum punishment authorized for the offense charged. The maximum punishment is confinement at hard labor for 1 month and forfeiture of 2/3 of 1 month's pay. Now, Durand, you are legally entitled to plead not guilty. And if you do so, it places the burden on the court to prove that you are guilty beyond a reasonable doubt. Your plea of guilty will not be accepted unless you understand its meaning and effect. Do you understand?
Yes, sir, I do.
Understanding this, do you persist in your plea of guilty?
Yes, sir.
In view of your plea, I find you, of the specification, guilty. Of the charge, guilty. I'm going to read some personal data taken from your service record. Place, USS Grady. Date,
This personal data helps the court decide on a proper sentence and is read to the accused to verify its accuracy. It also gives the court pertinent information as to the accused's financial condition and allotments he may have, if any. Before deciding upon the sentence, the summary court takes a number of things into consideration. The maximum sentence is fixed by law and regulations, but it is the court's duty to determine an appropriate and just sentence that will best serve the ends of justice and the disciplinary needs of this ship and the Navy.
Was what I have just read correct?
Yes, sir. Everything you read was correct.
There is no record of previous conviction. Now, Durand, it is your right at this time to submit for the court's attention any matters in mitigation or extenuation, that is, evidence which you think explains your conduct or lessens its seriousness, or evidence of your previous good conduct. You may, if you wish, testify under oath as to such matters, or you may remain silent, in which event the court will not draw any inference of any kind from your silence. In addition, you may, if you wish, make an unsworn statement. This unsworn statement is not evidence, and you cannot be cross-examined upon it. But the court may offer evidence to rebut anything contained in the statement. This statement may be oral, or in writing, or both. Do you understand what I have said?
Yes, sir.
Do you wish to make a statement or present any evidence?
Yes, sir. I wish to make a statement.
Go right ahead.
Well, sir, I don't remember any of this that happened. I'm very sorry it happened, and I realize now that I just can't drink and stay out of trouble. I think I've learned my lesson, sir, and I won't do it anymore.
Is there anything further you wish to say?
Sure sorry if I disturbed anybody.
Very well, Durand. The court will consider your statement when arriving at a sentence. The court will be closed. Orderly?
Yes, sir.
Take Durand out.
Aye, aye, sir.
C. The maximum sentence is confinement at hard labor for 1 month and forfeiture of 2/3 of 1 month's pay. He has a pretty good record. He's young, but he seems to be heading for trouble. Being drunk aboard ship isn't good for discipline, for the morale of the ship, or for the man himself. The punishment here should make him realize he's got to take this thing seriously. We'd lose his services if we sent him ashore to be confined in a brig. Restriction would serve the same purpose since we're going to be in port. Let's see that table of equivalent punishments. One-day confinement at hard labor is equivalent to 1.5 days hard labor without confinement, or 2 days restriction, or forfeiture of 1 day's pay. But restriction alone won't be enough. Forfeiture of pay would help teach him a lesson.
Orderly.
Yes, sir.
Bring Durand in.
Aye, aye, sir.
The court will come to order. Durand, it is my duty as summary court-martial to inform you that you are to be restricted to the limits of the ship for 2 weeks and to forfeit $25. The court is adjourned. Orderly, take Durand out and take these to the captain in the OOD.
Aye, aye, sir.
With adjournment, the summary court-martial has completed the formal trial. However, that isn't the end of it.
Under the Uniform Code of Military Justice, a review is accorded to every case that is tried by a court-martial. This is similar to the process of appeal in a civilian court, with one important exception. Under the code, every case is reviewed, whether it is requested by the accused or not. Thus, in effect, we have automatic appeal. In a summary court-martial case, like the one you've just seen, it works like this. If the accused pleads guilty or is adjudged guilty, the entire case goes on for review by the convening authority, who, in this case, is the CO of the ship. This review includes both matters of fact and law. If the convening authority finds errors in the record of the trial, he may take appropriate action. If he feels the sentence is too severe, he may reduce the sentence. However, and this is very important, as a protection to the accused, no sentence may ever be increased by a reviewing authority. The next step is review by a higher authority known as the supervisory authority. His position is always such that he is completely removed from the command which convened the court, so that he may exercise his judgment in a detached manner. The supervisory authority is a general court-martial convening authority, or in some cases, the judge advocate general. He must be assisted in his review by a certified law specialist who reviews the entire case up to this point and makes appropriate recommendations. Thus, before a summary court-martial sentence is finally approved and becomes part of the accused's permanent record, the guilt of the accused and the legality of the proceedings are considered by the summary court-martial, the convening authority, and the supervisory authority. Once a conviction has been finally approved, it becomes part of a man's permanent service record. If there is a previous conviction on a man's record, the court, under certain circumstances, may consider this and impose a more severe sentence, up to the maximum prescribed by the Manual for Courts-Martial. Always provided, of course, that the sentence is within the statutory power of the court to adjudge. In the case that we've just been discussing, one reason why Durand did not receive the maximum sentence was that he had no record of previous convictions. Thus, many factors enter into the consideration of each individual case. And in each case, it is the obligation of naval justice to protect the innocent as well as to punish the guilty.